now. So lectures are going to be recorded, and you will have an access to these lectures later on. As soon as you leave this meeting, in a while you'll receive an email with the link to the recorded lecture. Format of the exam. So let's discuss the format of your contract law exam. But please note that the format of the exam can be changed anytime without prior notice. So it is absolutely essential to read the instructions carefully before you begin your exam. Typically, you are required to answer 4 out of 8 questions, and there are 2 types of questions in an exam: essay questions and problem questions. So it is up to the student to decide what kind of question they prefer answering, and you have to find your own preference of your exam questions. A lot of our students find problem questions easier to answer because in the essay questions you have to write very analytically, and in the problem question, of course, you have to write analytically, but not as much as you are required to do in an essay exam. And in a problem question, the key is to identify all the issues that are that should be addressed in that problem question. Some are primary issues, some are secondary issues, but the same amount of time should be given to each issue. So you should spend almost same amount of time discussing those issues that you have identified in a problem question. Another important thing, always remember, while attempting a problem question, you must argue both sides. You must argue for both sides. So I've seen a lot of students who had this problem that they just argued one side of for one party. For example, they just argued for the defendant, and they just didn't argue for the claimant side, and they had difficulty getting good scores. So I'll give you a tip today. The best answer in law is always maybe. For example, if you ask yourself a question while solving a problem question, is it a valid offer? Your answer should be maybe, and then argue both sides. It is a valid offer because so and so and so, and it is not a valid offer because it is because of these issues and these case give reference of the case law, and then close your argument with the side that has more case law back it, unless you have a very good reason of backing the other side. So for every issue, argue for both sides. And in future, as lawyers, you do not know whether you will be taking a case from the claimant or from the defendant. As a lawyer, you must also think what the other party is going to put forth as their argument, so that you have your counter argument ready. So it is very important to look at the both sides. Okay, so let's now come to the category of English law. As I said earlier, it is important to put everything into category to make your life easier and to make your legal studies easier. English common law is divided into 2 types of laws: public laws and private laws. Public laws are those that govern the relationship between citizens and the state. It sets out basic rules of our society, and it also defines what will happen if those rules are broken. Every state, every country has some laws governing the society so that everything runs smoothly. So can you name an area of law that is considered public law, that is considered that comes under the category of public law? I have a hint here for you: R versus defendant. So I need a volunteer. If you can just write in the chat box that you volunteer to tell us what, to give us an example of an area of public law. Sandeep. Okay. Yes, Sandeep, please unmute yourself. Hi, Sandeep.
How are you?
Good. So, what area do you think comes under public law?
I'm guessing laws like criminal law and administrative law could come under public law.
Excellent, excellent. Yes. So, criminal law and administrative law are the examples of areas that come under public law category. Thank you, Sandeep. All right. So, as you have seen in the criminal law, all the cases are R versus defendant. So, this R, what does this represent? It represents Crown or Queen Regina versus defendant. Very good, great. Yes. And I see that a lot of people also answered, such as Jennifer, Caroline, Yasha. Excellent. Okay. So the other area of law is private law. This governs disputes between private bodies, such as between individuals, between persons, or between business entities. Examples of a case of private law. Can you give me an area of law that is private law? You can write it in the chat box. Family law, contract law. Excellent. Absolutely. So contract law, this means that contract law comes under the category of private law because it governs the dispute between persons, between you and me, between you and your contractor. I'll give you an example. For example, a contractor is remodeling my house. He did not provide the services that he had promised. Is it between me and him or between me and the state? I guess you know the answer. It is between him and me. Now, my question is, we all know this is a dispute between the contractor and myself, but does the state play any role in it? What kind of role does the state play? The state, of course, is going to provide courts. The state is going to provide judges, but it is mainly an issue that between two individuals, me and the contractor, so claimant and the defendant. Okay, let's bring us to the question of a situation where the distinction becomes a little blurred. What about a local authority that borrows money off of a bank and does other tasks that is usually performed by private individuals? If a local authority sells me a house. So in these cases, distinction becomes a little bit blurred. But remember that even in these situations, private law principles are going to apply to the public body that is in question. Okay, so we have decided that contract law is a part of private law. Now let's look at the categories of private law. Okay, so there are two categories of private law: rights in rem versus rights in personam. What is the meaning of rem and personam? So private law distinguishes between property rights and obligations. Rem here means thing. So rights in rem or property rights, it connects a person to a thing or property. You have a property right in your contract law book that you have purchased, for example. You have a property right in the computer that you're using right now. If you're using your own computer, if you're not in a net cafe or anything, in that case, you will have the right to use it, but you will not have the right in the computer itself. So if anyone, for example, if anyone takes your book away without your permission that you have purchased, he or she is interfering with your right in that book and thereby commits a wrong against you. And for example, if I take away your laptop, so I am infringing with your right in the laptop. So I have committed a wrong against you. And the rule applies to not only that particular individual, does not apply particularly to me. It is good against anyone who interferes with your right to that book. In simpler words, it is not a personal right. It is not between just you and me. It involves your right in that book. So anyone who interferes commits a wrong against you. And what are rights in personam? If you look at the word personam, what do you think it means? Let's see. Let's see the chat box. Person, yes. Personal between individuals. Excellent. Face to face, good, good, okay. So it's between persons. So personam means person. All right. So personal obligations connect one person to another and not to a thing. Example, if you promise to deliver dinner to my house and I promise to pay you $20 for it, then an obligation between you and me is created. Now, if let's suppose you come to my house with the dinner and I do not pay you after the delivery, or I had my money ready and I'm waiting for you to deliver your promise, but you do not show up at my house with the dinner, then the obligation is broken. So whoever breaks the obligation will then have to provide a remedy. So those remedies are mostly in the form of compensation. So in this situation, we are connected person to person, not person to person. So contracts connect people in this person-to-person way, and thus gives rise to personal rights and obligations rather than property rights. So when I say that contracts, it's person-to-person relationship, does not give rise to property rights. Do you think of any complication here? The complication may be that there's always a thing involved in a contract. When it comes to contract, we sell things, we purchase things, it is always something involved. But the main obligation that we look into when a contract is breached is personal obligation. I need you to give me some examples where the things are involved when it comes to contract. For example, a contract, we did a contract, and give me a situation where thing or property is involved. Buying a house, yes, Sandeep, very good. Buying a house is one example. Purchasing land. All right, good. So those are some examples where the things are involved. So I promise to sell my house to you, and you promise to pay me £200,000. What kind of obligation is created by this promise? the main obligation, the primary obligation. So when I convey my house to you, when I have conveyed my house to you, I have transferred the property rights to you. Only then, at that instant, property rights gets effective. Now, before that, it's only personal obligation. It's a promise. It's between you and me. So property rights do not come into play unless I have conveyed the rights to you. So mainly, if we just look at this scenario that I promised to sell my house to you and you promised to pay me £200,000, a personal obligation is created. So here's a diagram to explain what we just discussed. So if you look at the left-hand side, that's me and that's you. So I have my property right in my house. Okay, that's just between me and the house. But what do I have between you and me? It's the obligation to sell the house. So there is no property right playing any kind of role here between you and me. Okay, all we have is an obligation. I have an obligation to sell the house, and you have an obligation to pay me £200,000. So it's a personal obligation between you and me. Okay. Now let's suppose if I convey the promise is fulfilled, you paid me £200,000, and I conveyed my right to you. I conveyed the property to you. So look at the picture on the right hand side. It's just you and the property, and I am out of the picture. So main point of this diagram is, what do I have between you and me? It's the obligation. It's a personal obligation. So obligation to sell, obligation to pay. Okay, so now let's look at during your course of study of contract law, you are going to come across the complications where law of torts overlaps with contract law, and you need to know the difference between contract law and tort. So contractual obligations are by way of consent or choice to perform for each other, and obligation is voluntary. It's voluntarily created. So I promised to convey my house in return for the payment from you, right? So your obligation to pay me and my obligation to convey my house to you arose due to our consent. We both agreed that we are going to, when we made this promise, we agreed. So that's one example of contractual obligation that we just discussed. Now, some obligations are imposed rather than chosen. So, let's take an example. An example of a careless driver. Let's name him Sam. Obligation to drive carefully is imposed by law on Sam, whether he likes it or not. But let's suppose he was backtailing me and crashed into my car. Now, law imposed a secondary obligation on him to pay compensation to me. So that he had not, we had not agreed to that obligation. Sam and I had not agreed to that obligation. That was the obligation that was imposed on Sam by law. So once he has broken that obligation, he has to pay me compensation. The law enforces him to pay me compensation. And remember, damages and compensation is paid when a contractual obligation is broken too. Then what's the difference? Let's go back to our example of me selling you my house. If you do not carry on your promise to pay me, the law will enforce this contract and will ask you to pay me compensatory damages. Okay? So the aim of compensatory damages, the most common damages in contract law, is to make the injured party whole again. So if you did not pay me £200,000, I am the injured party, and the law is going to force you to pay me so as to make me whole again. On the other hand, in tort, such as in the case of Sam, if there was any misconduct involved, punitive damages may also be awarded to punish the defendant and to deter him from committing future torts. In English contract law, traditionally, damages for breach of contract are not punitive in nature. So just remember this. This is one of the main differences between contract and tort. One is that obligation is voluntary in the case of contract, whereas in tort it is imposed. And then in tort, there can be punitive damages awarded to punish the defendant. Whereas in tort, in English contract law, traditionally, damages for breach of contract are not punitive. It cannot be used to punish the defendant for the breach. Again, this is like many other rules in English common law or in any common law. This is a general rule, and there are some exceptions to it. And there is some argument on this amongst legal commentators that punitive damages may be available in extreme cases of fraud or where contract and tort overlaps, but it's very rare. So, so all of these things, such as punitive damages, this does happen in the case of imposed duties that are created by law of wrong. And you will later on read more about the common law wrong. So the tort is a common law wrong. So these are the main differences between contract versus tort. And next year, when you study tort, or if you're taking tort this year, you will be able to compare both the areas of law. Sometimes it gets confusing, but it also helps when you compare both areas of law. So whatever we have discussed is in this diagram that you are seeing right now. So English law, again, just to reinforce or just to recall what we have studied, English law is divided into two categories: public law, private law, right? And then there are obligations and property rights. So for contract law, you are mostly concerned by the left-hand side of this diagram, where you see obligations and then voluntary and then contract, and after that voluntary chosen obligation assumed in exchange for a benefit. So in this course, in contract law, you are concerned by this area of law that is on the left-hand side of this diagram. Okay. As you study contract law, there are going to be some more problems or complications that you're going to face. One of those are statutes and EU law. So as you know, most of our principles that are developed in the courts are through case law. So having said that, please keep in mind that some statutes are also important, as they contain important principles of English contract law. During the course, I advise you to make a deliberate effort to learn about these statutes, and especially learn about the instances or cases where these statutes are applied. So just not only read the statute and understand it, but also see in what cases were these statutes applied. And that is how you refer to a statute in your exam as well. So just not write the statute in your exam paper. Also tell the examiner how and when that statute was applied. Important thing to remember is that in English law, judges are the ones who decide what Parliament meant by the words of the statute. So by just stating the statute will not suffice. You will have to give the interpretation of the judges by way of referring to the cases and decisions in your exam paper. And then a significant part of contract law is affected by EU legislation. But there are only a few areas that you're concerned with in your syllabus of University of London. And those are unfair terms specifically, and then there are some other directives as well. But you do not need to be concerned much about EU law. So mostly the main area is the unfair terms, and especially the regulation of the terms of contract. So only these are the areas that you need of EU law that you need to know. But of course, it is good to know other directives where the area of common law, contract law is affected. And you can find that in McKendrick and your study guide. And later on, when we come to study those areas, of course, we are going to discuss those. Okay. So in past, up until 1873, in England and Wales, there were two separate court systems which dealt with contract cases: courts of equity and courts of common law. Equity. Does anyone know what does equity mean? Literally, the word equity. Equating. Can you be more specific? Equality, right? Absolutely right. So equality or fairness. So the equity in these terms are taken to mean as equality and fairness. Equity is said to supplement the common law where it is deficient. So it comes into play only when the common law is deficient. And equity has developed its own principles over the time. And you will come across many equitable principles in the course of studying contract law. Some examples are estoppel and undue influence. Equitable intervention depends a lot on the clear conscience of the parties. So this is one of the most important principles of equity. And there is also a maxim that is used to describe this. Do you know that maxim? For equity, to describe the clear conscience. Excellent, Yasha. Very good. Good intention, Sandeep, yes. And Yasha said, let me read it to you. One should come with clean hands. Absolutely right. So the maxim that is used to describe this is, he who comes to equity must come with clean hands. This means that whoever seeks equitable relief must be clean himself, as in must have not be guilty of any form of misconduct. So so that was in past when there were two separate court systems. And after 1873 and in the present day, equity and common law are presented in our current court system. So both court systems were amalgamated, and now we just have one court system. But equity can be invoked whenever common law is deficient. So for now, just introduction to equity should be enough for you. Later on during the course of your study, you will study more about equitable relief. We'll spend a lot of time on that, and you'll learn more about equity in your common law reasoning as well. Okay, another important concept. As we said that contracts are voluntary obligations created voluntarily, and it is absolutely necessary for the minds to meet. So meeting of minds was emphasized for making of contracts, especially in past it was emphasized a lot, and this was in line with the belief in freedom of contract. So you and I, if we want to create a contract, we must have a consensus, which means our minds must meet. So in past, a subjective approach was used to find the intentions of the party. So what was the intention of the party? The judge used to look at the individual particular intention of each party. What could be the possible problems with subjective approach of finding the intentions of the party in past? Any problem that you see with subjective approach of finding the intentions? Intention could be bad, yes, absolutely. It could be unfair to another party, yes. Hard to have a basis on which to know what the party's actual intentions were. Very good, excellent, Jennifer. So in court, this complication can arise that Jennifer mentioned. And anyone could say that I did not mean this, right? If you and I enter into a contract, and if there is a dispute, we go into a court, and I can always say that I did not mean it, and you mistook it. So there's no way to actually know what my intention was. Another problem is that individuals often forget, sometimes innocently, sometimes conveniently, as to what their intentions were at the time of the contract. So therefore, it is very difficult to prove them wrong when a dispute arises. So now courts do not use this subjective approach. It's gone. Now they use objective approach. Now objective to find the intentions of the party. So the focus of the objective approach is what would have been the intention of a reasonable person in the position of the parties. So instead of looking at, oh, what I meant, instead of looking at like what claimant or defendant meant at that time or intended at that time, now they focus on the reasonable person test, that what a reasonable person would have intended. Any problem with the objective approach that you see? And by a reasonable person, courts mean just a person, any person on the street. Here in the U.S., they have named that person as your average Joe. So so what an average Joe walking on the street would have intended? Do you see any problem with this approach? Excellent, Jennifer. It might not result in reflecting the actual intentions of the party. So the actual intentions may be sidelined. Sandeep, yeah. Sandeep says there is no 100% reasonable person. Right. So another problem, as Sandeep mentioned, how do you define a reasonable person? Does the reasonable person, should he be in the shoes of the claimant? Or should he be thinking from a reasonable person in the shoes of the defendant? That changes everything. And Sandeep also says it was difficult to establish a fair benchmark. Okay, unbiased, Yesha. That can be one of the benefits, that it is unbiased. So one of the main problems of objective approach is the actual intentions of the party may be sidelined if the reasonable person principle is used. And some argue that if we take the objective approach, it damages the claim that contracts are based upon the party's consent. Right? So what Joe would have intended, it does not, his intentions, like a reasonable person's intentions, might not represent the party's intentions. Thus, we cannot say that they were in consent, and that damages the main principle of contract law. So there are some arguments on objective approach, some in favor and some against, but this is the approach that mostly the courts are using these days. In the next lecture, we'll talk more about objective approach, and we'll do some more examples. Okay, so what does a contract look like? Some people think that contracts are always in a lengthy document, in a written form, in fine print. Is that true? Of course, there are some contracts that fit the first description, as in they are lengthy in length and they are in fine print. And there are some contracts where the consumers must be provided with the written details in order for that contract to be valid. Some examples are when you sign up for a credit card, for example. You might have seen it. It's a lengthy document with very fine print that you receive in mail. Or when you hit the agree button on or consent button when you are signing up for a credit card, or when you are purchasing a new phone. Again, it's a lengthy document that sometimes you read, sometimes you don't read, but they are obligated to make the consumer aware of the terms of the contract. And when you lease a house, so leases are again lengthy documents. But a vast majority of contracts are made informally, without any written down notes or any other record. Examples. Okay, I'll give you one example. For example, riding on a bus. If you rode a bus, you agree to pay, and the bus company agrees to transport you safely to your destination. Right? No written contract. It's just it comes into effect as soon as you ride the bus. I want you to take a moment and think of the contracts you entered into the past week. So this whole week, what kind of contracts did you enter into? Let's list some examples on the whiteboard. Let's do this activity. I'm going to open up the whiteboard here. Okay, so I'll start. So I'm going to click on the left, the arrow that is on the left-hand side, pointer. Okay, and then the T for text. Riding a bus. Okay. Can you try to write somewhere in the middle of the whiteboard? For some reason, I'm not able to see the three arrows. Okay. Yeah. All right. So write down your examples. Showing up for work. Excellent. Who said that? I'm not able to read the name. Can you move your arrow, please? The blue one. Purchase of food at grocery. Going to supermarket and purchasing stuff. Hailing a cab. Excellent. So, all right. What other contracts did you enter into? All right, Anisha, purchasing a textbook online. So she entered into a contract when she bought a book online. Sandeep, you bought gas. Excellent. That's another contract. What else? Ordering at a restaurant. Yes. Afnan. Eating in a restaurant. Yes. So all of these are examples of contracts. And it's amazing how many contracts we come across and how many contracts we enter into in one day or in 1 week. Car wash. Yes. Attending business meeting and making a deal in the meeting. Excellent. All right, great. So this activity was just to give you an idea how many times we come across contracts. So don't take it as a dry subject. It's very real life relevant. And whenever you come across a case, try to relate it to yourself. And that will help you with your studies. And it will make it more interesting. I am going to close the whiteboard now. Let's see. Okay, so we're back to our slides. All right. So these were all the examples of the contract. All right. A little comprehension check for you before we end our session today. So you have a true and false question in front of you. English law can be split up into private law and property law. True or false? Let's see. Use your chat box. True, true. False, false. Okay, yes. I got some trues and I got some false. And reason for people who said it's false is that the category is private and public. That's absolutely right. So property law, it is false, and property law is a subdivision of private law. It governs the right between two citizens in relation to things. The correct division at the level of private law is between private law and public law, right? So very good. Let's see. All right, which of the following are examples of rights in rem? There may be more than one correct answers. Rights in rem. My copyright in this question, my Ujala's copyright in this question. Your obligation to pay rent to your landlord, your right to possess the book on your bookshelf if you've purchased it, your duty not to commit an assault against another person. Which of the following are examples of rights in rem? All right, second and third. Okay, so a few of you are saying second and third, and just 3. Okay, Sandeep is saying 1 and 3. Caroline, 3. So mostly 3s. 1 and 3. Afnan is saying 1 and 3. All right. So 1 and 3, that is the correct answer. Rights in rem, of course, they are property rights, right? And it connects a person to a thing. So my copyright is a property right. So I wrote this question. This is my question, and I have a copyright in this question. So 1 is correct, and 3 is correct because the book that we assume that the book book is the one that you have purchased. So if you purchased a book and it's lying on your bookshelf, You have the property right in that book, right? So why is number 2 wrong? Your obligation to pay rent to your landlord. That is a personal obligation. Okay, there is no property right involved, right? Your duty not to commit an assault against another person. The part of public law, it can be tort, can come into criminal as well. Okay, wonderful. One more question. The basic distinction between contractual obligations and tortious obligations, as in obligations created by tort, is that tortious obligations are imposed upon the parties, while contractual obligations are voluntarily assumed as a choice made by the party. Tortious obligations being imposed by the law of wrongs are imposed on the parties who break the criminal law. Contractual obligations are imposed when parties make a contract. Which is the correct statement? One. Okay, I'm getting a lot of ones here. Some of you are saying 2. Let's see. In my opinion, 1 is correct. Why? This is the basic distinction. Although some contractual obligations appear to be imposed by the law and some duties of care appear to be voluntarily assumed by the parties, but this is the basic distinction. Why number 2 is not right? It's because torts are civil wrongs, but are not necessarily crimes. Do you see the word criminal law here in number 2? That is what makes it wrong. So torts are civil wrongs, not crimes. Okay, a contract must be made in writing in order to be binding. True or false? False. Absolutely right. Very good. Like we just discussed, we enter into a lot of contracts that are not in writing, such as riding a bus, eating at a restaurant, all the examples that we just discussed. Excellent. Okay, so next Saturday we are going to discuss the first requirement of a contract. So there are 3 requirements of a contract: offer and acceptance, consideration, intention to create legal relations. So next Saturday we are going to discuss offer and acceptance. Okay, and that's the end of our session today. Thank you very much, and I will see you next Saturday the same time. Whoever is present here today, please join the Facebook group if you are on Facebook. And thank you very much for your participation.